Y'all, we have some major news. A judge just gave a preliminary injunction against the Illinois assault weapon ban and magazine ban. But the judge also mentioned pistol braces and said the ATF is overreaching because pistol braces are part of the Second Amendment. This is absolutely huge. I want to thank the sponsor of the video, and that's Blackout Coffee. For those who have reached out to us and asked to be able to be part of our the shares that were offered, to be part of the growth of Blackout Coffee, well, that round has been opened back up again. So if you want shares to be part of the ownership of Blackout Coffee as we continue to grow and move forward, you have that opportunity again, backed by popular demand. Link is down below if you want to join our growing company. I thank you, John and his wife Rachel. Thank you. Our employees, thank you. And it means so much to me. blackoutcoffee.com/GNG. I'll also have the link if you choose to invest down below as well. Here on the screen is the first page of a decision that just dropped. And as you can see, there are 4 cases that were consolidated in which they were all suing Illinois for their assault weapon ban and magazine ban. Now, this judge gets it. In reading this decision real quick, he said things that we all think, and it's phenomenal. And this is the type of stuff that makes Jerry Nadler squirm. Check it out. The judge says, before the court are consolidated cases with requests for the imposition of a preliminary injunction under Federal Rule of Civil Procedure 65 Alpha to prevent the enforcement of Illinois' Protect Illinois Communities Act, or PICA, until there can be a final determination of the merits as to the law's constitutionality. Lead plaintiffs Caleb Barnett, Brian Norman, Hoods Guns and More, Pro Gun and Indoor Range, and National Shooting Sports Foundation, Inc., along with the plaintiffs from companion cases, herein collectively referred to as plaintiffs, filed motions for preliminary injunction. The Illinois Attorney General's Office, representing Attorney General Kwame Raoul, Governor J. Robert Pritzker, and the Director of Illinois State Police, Brendan F. Kelly, herein collectively referred to as defendants, filed an extensive response to the respective motions that included 14 exhibits. On June 23 of 22, the United States Supreme Court issued its opinion in New York State Rifle and Pistol Association, Inc. versus Bruin. Amongst other things, the Bruin court reaffirmed that the right to bear arms refers to the right to wear, bear, or carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action in a case of conflict with another person. Less than 2 weeks later, family and friends gathered in Highland Park, Illinois to enjoy one of the mainstay festivities of this nation's Independence Day celebration, a parade. They gathered to salute our country, our liberty, and our freedoms. During the parade, a senseless tragedy occurred involving firearms, and multiple parade goers were killed and wounded. Some months after that, the state of Illinois enacted PICA into law. The proponents of PICA cited the Highland Park tragedy as an impetus for passing the law. That law placed sweeping restrictions and outright bans on the sale, purchase, manufacture, delivery, importation, and possession of many firearms, magazines, attachments, stocks, and grips. PICA was immediately challenged as unconstitutional. As Americans, we have every reason to celebrate our rights and freedoms, especially on Independence Day. Can the senseless crimes of a relative few be so despicable to justify the infringement of the constitutional rights of law-abiding individuals in hopes that such crimes will then abate or at least not be as horrific? More specifically, can PICA be harmonized with the Second Amendment of the United States Constitution and with Bruin? That is the issue before the court. The simple answer at this stage in the proceedings is likely no. The Supreme Court in Bruin and Heller held that citizens have a constitutional right to own and possess firearms and may use them for self-defense. PICA seems to be written in spite of the clear directives in Bruin and Heller, not in conformity with them. Whether well-intentioned, brilliant, or arrogant, no state may enact a law that denies its citizens rights that the Constitution guarantees them. Even legislation that may enjoy the support of a majority of the citizens must fail if it violates the constitutional rights of fellow citizens. For the reasons fully set out below, the overly broad reach of PICA commands that the injunctive relief requested by plaintiffs be granted. The judge then discusses the legal thresholds to get a preliminary injunction, and I'm going to show you part of the last one, which is the likelihood of success on the merits. This is good, guys and gals. Listen to what this judge says, because he says what we all say on our side of the aisle. And not many judges have the stones to put in writing what this judge just did. This court must now consider the third issue, likelihood of success on the merits. Plaintiffs rely on recent Supreme Court decisions that made it clear that the Second Amendment protects the possession and use of weapons that are in common use. Plaintiffs contend there can be no question regarding the likelihood of success because the items banned under PICA are in common use today. The Second Amendment provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. A plain reading of this text would seem to land itself to the notion that PICA is in fact violative of the Second Amendment. However, before weighing the parties' arguments and the validity of PICA, it is first necessary to review the pertinent aspects of the Bruin decision as well as the Heller and McDonald decisions. All right, stick with me. We're going to go through the part right now that discusses arm braces, and the ATF right now, I'm sure they're pissed off about this. Let's go. Plain text analysis. This court must determine if the Second Amendment's plain text, as it was originally understood, covers plaintiff's conduct. If so, the Constitution presumptively protects that conduct. Defendants argued that PICA does burden arms as they are understood in the context of the Second Amendment. Defendants argued that accessories and weapons that are most useful in military service are not arms under the plain text of the Second Amendment. The defendants did not challenge that plaintiffs were all law-abiding citizens such that they hold the individual right guaranteed by the Second Amendment. Further, defendants did not challenge that possessing the restricted items falls within the ambit of keeping for the purpose of the Second Amendment. This court will first address the defendant's connotation that non-essential accessories are not within the scope of the Second Amendment's plain text. PICA outlaws possession of a semi-automatic pistol with a detachable magazine if it is equipped with any of the following: a threaded barrel, a shroud attached to the barrel, or that partially or completely encircles the barrel, a flash suppressor, or arm brace. Sound familiar? PICA further outlaws possession of a magazine for a handgun capable of holding more than 15 rounds of ammunition, and of a semi-automatic pistol that has a fixed magazine with a capacity to accept more than 15 rounds. Defendants contend that such items are not necessary to the functioning of a firearm and are thus not arms, and therefore not protected by the Second Amendment. The defendant's argument is not persuasive. The Seventh Circuit has recognized the Second Amendment as extending to corollaries to the meaningful exercise of the core right to possess firearms for self-defense. It is hard to imagine something more closely correlated to the right to use a firearm in self-defense than the ability to effectively load ammunition into the firearm. The Third Circuit recognized the importance of this corollary and held that a magazine is an arm under the Second Amendment. Further, defendants' own expert defined high-capacity firearms as handheld arms with a capacity greater than 10 rounds, recognizing that Illinois statute allows up to 15 rounds for handguns. Defendant's expert is clearly referencing magazines and incorporating such into his definition of a firearm. This court agrees that magazines are arms as used in the plain text of the Second Amendment. Plaintiffs are correct that this is not even a close call. If defendant's own expert incorporates magazine capacity in the definition of a firearm given his level of expertise, it would be unreasonable to expect the original public meaning of the plain text not to reflect a similar understanding. All right, let's talk about braces. The Seventh Circuit held in Ezel that Chicago could not prohibit law-abiding citizens from target practice at a firing range because doing so interfered with the meaningful exercise of their Second Amendment right. PICA also interferes with the meaningful exercise of Second Amendment rights for one group of individuals, those with disabilities. To provide one example, consider arm braces for semi-automatic pistols. As noted above, PICA prohibits the use of an arm brace on any semi-automatic pistol with a detachable magazine without any caveat or exceptions. The Department of Justice has also attempted to regulate possession and registration of arm braces. See factoring criteria for firearms with attached stabilizing braces. However, one notable distinction exists. The Bureau of Alcohol, Tobacco, Firearms, and Explosives has recognized that such braces are necessary for those with disabilities to use a firearm by directing that this rule does not affect stabilizing braces that are objectively designed and intended as a stabilizing brace for use by individuals with disabilities. As reason and the ATF final rule evidences, Braces are needed by certain individuals with disabilities to operate a firearm. Thus, arm braces are an integral part of the meaningful exercise of Second Amendment rights for such individuals and can also be considered an arm. Let's jump to the conclusion. Plaintiffs have satisfied their burden for a preliminary injunction. They have shown irreparable harm, with no adequate remedy at law, a reasonable likelihood of success on the merits, that the public interest is in favor of the relief, and the balance of harm weighs in their favor. Therefore, the plaintiffs' motions for preliminary injunctions are granted. The defendants are enjoined from enforcing Illinois statutes, along with the PICA amended provisions set forth in blah blah blah, including subparagraphs 11, 14, 15, and 16 statewide during the pendency of this litigation until the court can address the merits. The court recognizes that the issues with which it is confronted are highly contentious and provoke strong emotions. Again, the court's ruling today is not a final resolution of the merits of the case. Nothing in this order prevents the state from confronting firearm-related violence. There is a wide array of civil and criminal laws that permit the commitment and prosecution of those who use or may use firearms to commit crimes. Law enforcement and prosecutors should take their obligations to enforce these laws seriously. Families and the public at large should report concerning behavior. Judges should examine their prudent judgment in committing individuals that pose a threat to the public and imposing sentences that punish, not just lightly inconvenience, those guilty of firearm-related crimes. It is so ordered. On today's date, April 20th of 2023, Judge Stephen P. McGlynn, U.S. District Judge. And he is judge in the Southern District of Illinois. And guys and gals, this is a ginormous win. Illinois, you have just gotten your assault weapon ban and magazine ban halted. The case is going to continue. Another big thing is it mentioned arm braces. Arm braces are now, according to this judge's decision, unarmed. We already know they were, but the DOJ and ATF are trying to say that they're not. Well, this judge just said, yes, they are an arm, thus protected by the Second Amendment. This is great. We just got our first win on arm braces, and it didn't even come from the cases suing the ATF. This is phenomenal. Guys, like the video, share it. I'll have the description pinned down in the description below. The decision pinned down in the description below. If you want to stay up to date on all the things happening in the Second Amendment, from lawsuits to bills to decisions by courts, then this is where you need to be. Guns and Gadgets is the premier source for Second Amendment news. And if you wouldn't mind, like the video and share it, and also subscribe while you're here, I would greatly appreciate it. Till we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. I'll see you all in the next one. Take care. Big news. This is huge.